Tiger Woods blew a 000 on his breath test. 0 alcohol detected. And he still got arrested for DUI. Now, I want you to hold that thought because here's what the internet is doing right now. They're running that mugshot. They're zooming in on his bloodshot eyes. They're talking about his history. And everyone has decided that he is guilty. But I am a criminal defense attorney. And when I look at that case, I see something completely different. I see a man who just survived a serious car crash. A rollover who explained to officers that he has a documented history of surgeries and physical injuries. Who blew 0 on a breath test. And I see a system that arrested him anyway. So today I'm going to break down this case, not for gossip, but for the law, because what happened to Tiger Woods can happen to you, and you need to understand why. Let's go. Let me give you the additional facts of this case, not the headline version. On March 27, 2026, Tiger Woods was involved in a serious car crash in Martin County, Florida. His vehicle collided with another car and it rolled over onto the driver's side. Tiger Woods was alone in the car. He had to crawl out through the passenger door. Hear that again. He crawled out of an overturned car. Officers responded. DUI investigators were called to the scene. According to the Martin County Sheriff, and I'm going to quote him here directly, Tiger Woods did exemplify signs of impairment. They administered Field Sobriety Test at the scene. Then they gave him a portable breath test. He blew 000 3 times. That's 000. 0 alcohol detected. He then refused a urine test. Because of that, a refusal, he was arrested and charged with 3 misdemeanors: DUI, property damage, and refusal to submit to a lawful chemical test. He was booked into jail and his mugshot was taken. His eyes appeared bloodshot, and within hours, that photo was everywhere. Now, let's talk about what that actually means, because most people watching the news right now have no idea what any of this actually proves, or more importantly, what it doesn't prove. Here's the question nobody in the media is asking. If he blew 0, what exactly are we saying he was impaired by? Because right now, nobody knows. And that's the point of this video. Let's start with the breath test, because I think people hear he blew 000 and they assume he should have ended the investigation right then and there. And honestly, in a fair world, that would raise a massive red flag. Here's what you need to know about the portable breath test, or the PBT, the device officers use on the side of the road. That device is often not admissible in court. In most states, including Indiana and Florida, portable handheld breath test that an officer uses at a traffic stop is considered a screening tool only. It is used for the benefit of the officer at the scene to help them decide whether to continue their investigation. It's generally not admissible as evidence of guilt in a criminal trial. The evidentiary breath test, the one that actually counts, is the one that's administered at the jail on a certified machine. It's usually a breathalyzer 9000, a Data Master. There's other brands of these certified machines, but that device has to be calibrated, certified, and operated by a trained operator. Tiger Woods was not given that test. He was given a roadside PBT and he blew 000. He was then asked for a urine test and he refused. So what does a state actually have? They have a 000 on a screening tool that isn't admissible in court, and they have a refusal, and they have a police officer's opinion that Tiger showed signs of impairment. That's it. Now, is refusal a crime? In some states, including Florida, yes, it is. Refusing to submit to a lawful chemical test is a misdemeanor, and that charge is real. I'm not disputing that. But a DUI, driving under the influence of a substance, that typically requires proof of that substance, and right now, they don't have that. So what were those signs of impairment they were talking about? Let's go. Right here, this moment right here is what I need you to pay particular attention to. When a DUI officer responds to a scene, whether it's a traffic stop or a crash, they're trained to look for specific signs of impairment. These are documented in NHTSA, that's the National Highway Traffic Safety Administration's manual on standardized field sobriety testing guidelines. The signs they look for are things like bloodshot, watery eyes, slurred speech, unsteady balance, swaying while standing, slow or confused responses, a flushed face, the smell of alcohol, inability to follow instructions. Now, I want you to think about what it looks like to be in a serious car crash, a rollover perhaps. Airbags are deployed. When airbags are deployed, they release a combination of chemicals and a force equivalent to being punched in the face. Eyes are going to be red. They're going to be watery. This is a documented physiological response to an airbag deployment. And to make matters worse, somebody that's been in a severe car crash, such as a rollover, is experiencing severe physical trauma. The heart's pounding, adrenaline is surging through your body. You may be disorientated, you may be shaking, you may have difficulty following instructions. Not because you're impaired by a substance, but because you survived a terrifying accident. If you have a head injury from a crash and in a rollover, that's entirely possible. You may have what's called a traumatic brain injury, mild brain injury. You may even have a closed head injury. But even a mild concussion can cause confusion, difficulty with balance, slurred speech, and delayed responses. These are the exact same signs a DUI officer is trained to look for. There is published research, and in fact, any doctor or nurse can tell you the signs of intoxication can be mimicked by somebody surviving a car crash. In fact, the best DUI officers I know of, whether at trial or in deposition, will tell you, yes, being in a car crash mimics signs of intoxication. They just do. And here's what makes Tiger's case even more complicated. This man has had multiple serious surgeries. He has documented physical injuries to his legs. He told the officers this. They said, and I'm quoting from the sheriff's press release, they took that into account and they arrested him anyway. The question a defense attorney asks is simple. How do you separate the signs of a car crash from the signs of drug impairment when they both look identical? And the honest answer is, without a confirmed substance in his blood, you can't. And that brings us to the field sobriety test. There are 3 standardized field sobriety tests that NHTSA recognizes: the horizontal gaze nystagmus, HGN, the walk and turn, and the one-leg stand. Here is what's important to understand. These tests were designed and validated under controlled conditions, not after a car crash involving a rollover. These tests assume the subject has no physical injuries, no medical conditions, and there's not been a trauma type event. The walk and turn requires you to walk heel and toe and come back. If your leg has been surgically reconstructed, as Tiger's has, that test is compromised from the start. The one-leg stand requires you to stand on one foot for 30 seconds. Same problem. Tiger's physical history makes that test essentially meaningless as evidence of impairment. The HGN test, where the officer moves a pen or a light in front of your eyes and looks for involuntary eye movement, well, that test can be affected by head injuries, by physical trauma of an airbag deployment, and certain medical conditions. In fact, I believe there's 40 ways HGN can be present that are separate and distinct from alcohol or drugs. In fact, when you talk to doctors and nurses about using the HGN to determine impairment, most doctors and nurses laugh because that's not how the test is designed. Now, let me say something direct. I'm not saying Tiger Woods is innocent. I'm saying he has not been proven guilty, and there's a very big difference between those two things. Now, we have a foundational principle in this country. It's baked into the Constitution of the United States. It is the bedrock of our entire criminal justice system. You are innocent until proven guilty. Not innocent until the mugshot goes viral. Not innocent until the internet decides. Not innocent unless you have a prior arrest record. Innocent until proven guilty. Tiger Woods is a prior DUI arrest in 2017. I understand that. The internet will not let you forget it, but a prior arrest is not a conviction on a new charge. His history does not eliminate the rights in his case. It does not lower the burden of proof. It does not allow the state to skip the part where they actually prove what substance, if any, was in his system. Right now, the state of Florida has charged Tiger Woods with DUI. What they have to do is prove in a court of law to a judge or jury is that he was operating a vehicle while impaired by a controlled substance or chemical compound. They have no confirmed substance. They have field sobriety tests administered after a rollover crash to a man with documented surgical injuries. They have 000s on a non-admissible screening device, and they have a refusal. That's their case. And a good defense attorney, and Tiger will have an excellent one, is going to take apart every piece of that case. This is not about defending Tiger Woods, the celebrity. I don't know him. This is about defending that principle, because the same analysis that applies to Tiger Woods on a Florida highway applies to you when you're driving on the road. If you are ever in a serious accident and an officer starts asking you questions, be on the lookout, because they may try to do to you what they did to Tiger. So let me bring this home. Tiger Woods blew 000. His car had just rolled over. He had airbags in his face. He has documented surgical injuries. He told officers about his medical history, and he still ended up in handcuffs. His booking photo is now circling the internet, and when everyone looks at that, they're automatically convinced of what it means. But what it actually means legally is very little. Bloodshot eyes are not a conviction. Field sobriety test at a crash scene is not a conviction. A refusal is not a conviction for DUI. Proof of a substance demonstrated beyond a reasonable doubt in a court of law, well, that can make a conviction. We are nowhere near that yet. Now, if you watch this video this long, I ask you to like this video, subscribe to my channel, leave me a comment what you think is going to happen with this case. I would love to know your thoughts. If you don't have any thoughts about the case, leave me a comment about what you think about this jacket. I like it, but a lot of people don't. I don't know why. Or you can let me have a comment who you think I remind you of. Please don't say Turtle from Entourage or Jack Black. It's messing with my self-esteem. And I don't need that. If you or a loved one are facing charges in the great state of Indiana, give me and my team a call here at the Marc Lopez Law Firm. We would love to talk to you about your options. The number is 317-632-3642. And remember, always plead the fifth.